Hey, good evening, everybody. Welcome to Conant Show. And still flying solo this week. I've been a little too busy to wrangle up a guest, so I've got other things on the plate. And there's a few things actually I want to mention tonight, and that is it's come to my attention that our town supervisor, Jeremy Wilbur, has crossed the Great Divide. And I want to express my condolences and sadness to his family, and that it's my wish that his spirit journey be a good and happy one. So it's kind of a sad day for Woodstock. And I'd like to thank Paula Gloria Barton for her engineering skills to keep the shows going here. And also I'd like to thank the town of Woodstock for supporting live TV, public access TV, free speech, informative. And you know, this is for you, your channel in Woodstock, and you know, never feel that you can't support us by giving the town a jingle and saying, hey, let's get some new equipment in there. So I'm always pushing for some updated new equipment and user-friendly, so that more TV producers can have a better, easier, more professional time putting some shows out for you. And Happy New Year, 2017. My gosh, that was quick. Just chewed right through yet another cycle of the sun. And I'm grateful that we're getting off with a pretty easy winter so far, but I sure do like snow, so I hope we get some of that too. And I trust everybody out there is in good health, and everybody got to see their friends and families. And in my last show, as I mentioned, it's always kind of a sad time of year because I become very aware of a lot of people who don't have friends and families to see. So I kind of always like to mention that if you know somebody who's shut in, it's a good idea to maybe give them a jingle or say hi or something. So coming down the home stretch of a legal imbroglio that I have found myself in, we have a dynamic transpiring in Woodstock, and well, Ulster County really, and it has to do with the law, and it has to do with fraud is the best way to put it, and how this fraud has really illustrated for me and my partner the depth of what can go wrong in your world when you're unjustly accused and attacked, and the accuser and attackers, in this case there's a gang of them, use the system inappropriately. And so, you know, in addressing the powers that be over the past going on 14 months now, 13, 14 months, and addressing the irregularities and incorrect procedures and lack of due process in a criminal charge has been a real education in how a civilian and a person, you know, citizen, has to interact with the powers that be, and how those powers that be seem to function in concert with each other. So I'm going to read a little bit to illustrate what the scenario is, and educate the community as to the nature of this particular scenario. So I wrote a few documents. One of them I have pulled up here is a motion to intervene. And it was kind of an interesting thing. It was dismissed, but I should have really appealed the dismissal to make the judge answer to it. But, you know, ordinarily, or this may have been even a precedent, one is not allowed procedurally to intervene in a criminal case. You are, however, you know, allowed to intervene in civil cases. And the reason I elected to go ahead and try it is that, well, it can't hurt, but it also made aware to the various actors and players in the scenario, which include a justice court judge, a prosecutor, county prosecutor, and lawyers, and of course the victims, in this case myself and my partner. So to quote from it, I'm making this motion to intervene because my rights are not being protected by anyone in this case. If my partner is convicted in this case of criminal possession of stolen property, it will harm the reputation of our business and harm me financially, and we will be cast in a false light. I'm also making this motion to intervene because my constitutionally protected rights are not being represented or protected by any party. This court does not have the facts to make an informed decision, among other things. Facts not considered by this court. 1, it is a fact that no alleged stolen property was ever found by any police agencies in our home, in our possession. There was no search and seizure conducted by police with a search warrant in hand. This has been my home with my partner more than 1 year. It is a fact that our accuser and her accomplices unlawfully entered our property and committed home invasion and denied my partner freedom of movement and destroyed property and unlawfully removed property on the 24th of November 2015. This is a matter of police record by our accuser's own admission to the police. 2, due to the fact there was no police execution of a search warrant and no police present at any time in our home, any alleged evidence against my partner is hearsay and inadmissible. This fact is being ignored by our own attorney, who should have brought this to the attention of the court as directed by my partner. Another fact, my partner stated to me after meeting with her attorney that she told him firmly that she would sooner eat her own liver before admitting to anything she didn't do, and she would not take a plea. In spite of her directive, our attorney consulted with the prosecutor to formulate a plea. This was quite upsetting, as we found out over a period of 6 months that the timeout date, you see, when a person is accused of a felony, and you have a thing called a grand jury right, or hearing, right to a grand jury hearing. And the theory of it is that you would have your opportunity to say, hey, these charges are, bogus. This is my side of the story. That's the theory of it. In practice of it, frequently, the grand jury is educated by the prosecutor to a certain degree, and that can frequently tilt the grand jury to an unbiased position. But not necessarily, but in any event, it's your right to a grand jury hearing. And that's where you are indicted or you're not indicted. And so the timeout date came and went, and my partner was quite confused as to why she had not gotten any word one way or the other as to the disposition of the charges. Were they dropped? What happened? And what happened is that just more appearances in the lower court and more legalese bandied about. But there was a confusion because in the end of it all, the attorney calls Laura and offers a great plea. And it was not the desired message that we wanted to hear. And ultimately, we had to move forward with some kind of strategy. And in any event, the curious thing about this is that we wanted to know what happened to the grand jury hearing. Where did it go? And in asking those questions, I was observing a conversation between the judge and the lawyer. Well, what's going on here? Do I have, the judge says, do I even have jurisdiction? Who has jurisdiction now? So he didn't even know if he had jurisdiction. And in the letter that my partner wrote that complained vociferously that she did not know nor grant permission for her right to a grand jury hearing having been waived had occurred, and this was unacceptable. And in this discourse between the lawyer and the judge, I heard with my own ears, well, what happened? I heard it got sent up, which meant the case got sent back up to the grand jury for hearing, and then was sent back down, and then sent back up, and then sent back down again. So the grand jury heard the case twice and refused it twice, and now it has been kind of put down into the lower court, which is quite interesting because it doesn't belong there on a number of levels. Let me see here. So two particulars that have interest in this. And one is the lawyer, one is a friend that is also in the legal profession, were insisting that my partner take a plea that truth doesn't matter, and they want to avoid a big Woodstock drama trial, and this was most repugnant to me. And the two of them interfered with our relationship by telling my partner to get rid of me, not to listen to me, and that I was hurting her case. And when in fact I'm the only one actually trying to protect her interests and rights and get the facts on the record that the lawyers have failed to do, and without which the court record is defective. And if you have a defective court record, there's more problems. Truth and facts are our defense, not cutting a deal. So that was a real contention that is still a problem. But now it's moved past that, and as a informational tidbit, the threat of felony charges are gone because the grand jury refused to hear it. They threw it out not once but twice. Now, they didn't dismiss it, which I would have preferred, but they don't want to hear it, so the Superior Court doesn't want to have anything to do with it. That, to me, says that the prosecution has a very weak case or some other error that they're looking at. Could be from all the letters I wrote telling them that it was fraud. So The police that investigated this never found any evidence in our home and went solely on the word of our accuser, who created a crime scene, photographed it, submitted it as evidence to bring to the attention of the New York State Police, who failed to do a proper investigation. This person invaded our home, entered unlawfully with malice and forethought, using two accomplices, and held my partner against her will in her home to accost, prevent freedom of movement, harass, ransack, and remove thousands of dollars of our property from our home in a 3 or 4 hour period, under the guise that they were reclaiming what they were accusing my partner of stealing. When my partner tried to call the police for assistance, our accuser seized her phone and smashed it, and for these and many other reasons, my partner's rights to due process and equal protection have been grossly violated. And as a result, Investigator Kinderman of the New York State Police, and I'm using his name because he falsely arrested my partner on hearsay evidence without obtaining the facts for himself and without ever producing a warrant. So we have problems there. Now, we're challenging jurisdiction. And that's such a legalese kind of thing for average people to hear. When they hear what does even jurisdiction mean? And jurisdiction is, as far as I can figure, kind of the authority to act. In this kind of a procedure, in a legislative procedure, which is a court procedure. So I write, this court does not have jurisdiction due to fraud upon the court because of the fact that these people acted unlawfully and in defiance of directives by the New York State Police. They did invade our home, accosted and prevented freedom of movement of my partner, and these women proceeded to raid and ransack, destroy and damage and unlawfully remove thousands of dollars worth of property, including jewelry, paintings, artworks, belongings from our home. And this was acknowledged by our accuser to the New York State Police. So this did happen. It's not hearsay. The police know it. They have it on record. And they chose to ride with it. They thought that this was acceptable. I do not think it's acceptable. Therefore, there is no admissible evidence because there was no alleged stolen property in our home. No police officer with a search warrant came to our home. There is no evidence. There is no chain of custody of evidence. This has been verbally confirmed to me by both Investigator Kinderman and Senior Investigator Baker. They both stated to me that they told our accuser to let the police do their job and not to go and raid our home. So there's a lot of layers to this, and but I want to stick with the fraud that was perpetrated and how everything that comes after it is problematic. And which is the definition of fraud. Now I have a new document that we're constructing here, and this is to really hammer home to the point to the court officers that they've been informed multiple times now of this contention that the police never arrived with a warrant to search and seize anything. There was no inventory with a police officer to search and take anything. There was no second police officer as a witness or a third police officer to actually take custody of any alleged stolen property to put it under lock and key as evidence. Does not exist, didn't happen. Why? Because the accuser went ahead and raided the home and then showed the investigator, Kinderman, a pile of stuff on her kitchen floor that she claimed came from our home, but there's no evidence of that, only her word. And this seems to be good enough to fly for the district attorney's office here in Ulster County. And I'm challenging that. Part of my idea on this point is that if an individual is going to make a complaint about somebody, that, you know, so-and-so has my stuff, basically, to the state police, and then the state police say, I'm going to say this, you know, tells the person, okay, all right, you know, give us an inventory, tell us where to look, because that's part of the protocol of due process. They don't just actually get to come in your house and look wherever they want. The alleged stolen property has to be identified by the accuser, and the locations of such things have to be specified. So, top shelf of the bookcase on the right, in the living room, whatever, you know, there has to be protocols that are followed. None of this was followed. And my contention is if this person wants to act like a police person, then that person needs to follow the rules just like a police person. Stands to reason that they can't just an individual just can't come into your home claiming that you have their stuff and then clean you out of your stuff, and there be no repercussion because she complained first. And that was the excuse that we are being given by multiple police departments and the lawyers, that this is okay. It's okay for the civilian to override the directive of the police and raid my house. I don't know how you guys feel about it, but that's what happened. That's where this is going. So, you do research, you do homework, you write letters and you complain. You let them know what's going on. So we are demanding that the attorney take the lead with these directives and that we are compiling here. And we're demanding that the court take judicial notice of the following. And what that means, when you make a statement that you want to take judicial notice, that means the judge has to read that statement and then comment on it. So that, you know, that's one way of making sure your document is read all the way through. I am the victim of fraudulent accusations, and because of these fraudulent accusations, any and all jurisdiction is lost. The maxim of law. Fraud vitiates everything it touches. Therefore, jurisdiction is lost, and any judgments are void, not voidable, but void. And so what that means is that because of the fraud that had been perpetrated, starting with the false complaint, actually starting before that with other activities, but we'll get into that. That's another thing. Everything that comes after that in relation to this charge or case is fraudulent. It vitiates everything. It taints everything. All right, so that's that. Therefore, since the judge and the district attorney and prosecutor's office and other officers of the court, like your own attorney, were informed extensively at this point now, they can't say they weren't, of the fraud, you have a thing called misprision of felony. And what that means is an officer of the court, which could be a policeman, which could be a judge, which could be an attorney, once informed of a crime, and they don't immediately report, or even worse, they willfully conceal that crime, they become culpable and a party to the crime, to the fraud. Accomplices. Moving right along, take judicial notice. Number 2, Because the police failed to do a proper investigation, failed to execute a proper search warrant, failed to find any alleged property in my home, in our home, or in our possession, any alleged evidence is hearsay and inadmissible. Again, lacking jurisdiction and voiding any further proceedings. All right. Judicial notice, take judicial notice. Number 3, this court lacks jurisdiction and has failed to produce all jurisdictional facts supporting that supposed jurisdiction, which must appear on the record of the court. And that's a ruling, Pipeline versus Marathon, 102, and I'm quoting Crowell and Benson, 883 U.S. 22. So those are citing the actual cases where the rulings came from, and this is how you fight back, folks. You have to do your homework, and then you have to apply it. When acting to enforce a statute and its subsequent amendments to the present date, the judge of a municipal court is acting as an administrative officer and not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension of, as an agent for the involved agency, but only as a ministerial and not a discretionary capacity. And what we're talking about there is that, again, it's the lower court, your municipal courts, do not have general jurisdiction like your Supreme Court does, or your Superior Court. It has limited jurisdiction, which limits its ability to even hear certain levels of infractions or crime or what have you. The municipal courts cannot punish or do sentencing legally. They do it all the time, but not legally. And I'll get into that later. So, y'all probably heard of kangaroo court. All right. Now, the term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or other tribunal. And that's from Black's Law, 5th edition. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. And what we're talking about is that these lower courts don't have any legal standing to accept grants of judicial power. And if they do try to exercise those judicial powers, nothing comes of it. It's a nullity, not to be obeyed. Once jurisdiction is challenged, it must be proven. And again, that's a ruling from Higgins versus Levine, and that's Section 415, U.S. 533, Note 3. And you look these things up, and that's where you get these insights. No sanction can be imposed absent of proof of jurisdiction. So the point is that when you find yourself in a situation in a lower court with a serious charge, the first thing you should do is challenge the jurisdiction. Because then they have to prove, the court must prove how it has, by what right, by what evidence, by what proof do they have jurisdiction. And I found it curious that that particular day, that this exchange went on between the judge and the lawyer. Well, do I even have jurisdiction? Where did it go? Well, it went back, it went up, and it came back down, and went up, and came back down. What's going on? I don't know. And what about this matter with the grand jury hearing? Why didn't that happen? Did you, meaning the attorney, did you waive the grand jury right? And I heard him say no, which is interesting because that didn't hold up later. Later he said yes, but not to the judge and not on record. Then the judge said, well, who did waive the grand jury right? And the attorney says, no, I don't know. So there was a great deal of confusion going on. And again, the discussion was jurisdiction and the grand jury right to a hearing. Grand jury hearing as a right being waived. That's a serious thing. And so then moving right along here to other aspects of jurisdiction, there's a thing called subject matter jurisdiction. And when a court lacks subject matter jurisdiction, you have certain conditions. Quoting here, the right to adjudicate concerning the subject matter of a given case. To constitute this, there are three essentials. First, the court must have cognizance of the class of cases to which the one to be adjudicated belongs. So the court has to know what it's doing. It has to know the nature of the case, it has to know the particulars of the case, and it has to know whether it has jurisdiction to even hear it. That's one thing. Second, the proper parties must be present. The proper parties have never been present, just so you know. The accuser has never been present in any of these hearings thus far. Third, the point decided upon must be in substance and effect within the issue. So that's a little more esoteric of a thought for me at this point, but what I'm guessing here is that whatever it is that is going to be ruled on has to be of material value and substance to the charges or issue at hand. If the ruling doesn't address the grievance, then now you have another subject matter jurisdiction problem. The court loses jurisdiction, loses its authority. The municipal court is a court of limited jurisdiction, or an inferior court. An inferior court is of limited jurisdiction. Inferior courts do not deal with common law and do not have subject matter jurisdiction over common law issues. That, I assume, and I could be wrong, but I'm presuming here that criminal charges fall in the category of common law, accusations, and so forth. So a municipal court does not have jurisdiction over common law issues. Therefore, criminal charges should not be heard by this lower court at all. So we have a problem there. The statute that authorizes the court will define the jurisdiction. If the jurisdiction is limited in any way, then it is an inferior court. I think what that's saying is depending on the degree of the infraction or the crime or the issue at hand, if it is greater than the purview of the lower court, or of a court that is of limited jurisdiction in any way, the court is an inferior court and it doesn't have the authority to address the issue. These are subtleties. Sometimes it sounds like you're saying the same thing over and over again, and in some ways it is being restated in different ways, but there are nuances to these restatements, just so you know. So if it's a different word, I had a great teacher who used to say this, if it's a different word, it means something different. Just so you know. No two words mean exactly the same thing. There's synonyms, but just because they're synonymous doesn't mean that there's always going to be a difference, because it is a different word. It is made and comprised with different vowels and consonants, and therefore has a different meaning. And that's a whole other conversation. That's a really fun conversation. It's not quite so heavy. Anyway, another thing here is also, nothing shall be intended to be within the jurisdiction of an inferior court but what is expressly so alleged. And if part thereof without it, the inferior court ought not to hold plea. And again, that's a convoluted thought. Some of these statements are very hard to figure out. But what it's saying is that if there is something within the case that's being heard in an inferior court that is only a part of the case, but it is still exceeds the authority of that lower court, then the court can't hear the case at all. I think is what that's saying. So in other words, if it's an inferior court, it has to stay within the boundaries of its authority in that lower court. A court not of record is, or where the proceedings are not according to the course of the common law. So what they're saying here is, if the proceedings are not according to the course of common law, I have to come back to that, because that's a little too convoluted for my thought at the moment. I have to come back to. There might be an error there. A court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. So a court of general jurisdiction must be a superior court.
Unlimited.
Unlimited?
Yeah, they talk about unlimited jurisdiction.
Unlimited jurisdiction. And so that would be certainly a state Supreme Court on up to federal courts would be those kinds of courts that would have that kind of unlimited jurisdiction. All municipal courts are inferior courts of limited jurisdiction. Just so you know.
You know, I think sometimes it's the limited and unlimited is determined by the litigants. Because I was in a Supreme Court on my apartment issue in Gramercy Park.
Yeah.
And the judge was trying to get out of it, saying that it wasn't his jurisdiction. I got you in that shot, yeah. And but I had just sat there and heard a previous case where there were a whole bunch of lawyers on one side and a whole bunch on the other side, and he said on the record that he was a court of unlimited jurisdiction, and yet when he was talking to me, it seems all of a sudden it was limited. So again, I think that's a case of where you have to assert your will. You have to move the court.
Yeah, okay.
So I think you could make even a court of limited jurisdiction into a common law court. You're going to, it's like blow a whistle, time out, breaker. Let's get real. There's fraud here. There's blah, blah, blah like that.
Well,
then it's good you have people in the court with you.
Now I have heard that because of courts being clogged with more cases than they can hear in a timely fashion, that they will assign cases to lower courts to help relieve the pressure of the upper courts. And this becomes another curious situation, because that is assigning the lower courts these cases that are really, they're incompetent to hear.
Right. Well, that's kind of like
just to relieve the scheduling of hearings.
Yeah.
Begs the question of how legal that is, and now you have inferior and incompetent courts dealing with subject matter and jurisdictional issues that are beyond their skill set, perhaps.
Right, but they're kind of banking on sheepalism.
Right. Well, who would know unless you do the research?
Because people are trailing through just like sheep, and they're trusting what they're told. They don't know law.
Well, it's not that I don't think that people trust what they're told.
They don't know what else
They're
to do.
defeated into what they're told.
But you weren't. How did you do it,
Oh,
George?
no,
How
well,
did you do it?
I don't believe anybody.
You spent 500 hours learning law.
Yeah, more jurisdiction things. The court does not have jurisdiction to hear or adjudicate on a claim or counterclaim for malicious prosecution, false imprisonment, defamation, or criminal conversion. And I think what we're talking there is a lower court. So my counterclaim on behalf of my partner is malicious prosecution, false imprisonment, defamation, and fraud upon the court, fraud. And this brings us to something called void judgments. And void judgments equal no jurisdiction. All right, now there's a couple rulings here. One is Boyd versus the U.S., H6 U.S. 616. The court is to protect against any encroachment of secured liberty. At the common law subject matter, it is not within the jurisdiction. The court may dismiss the proceedings. Hang on a second, I'm not reading that correctly. At the common law subject matter is not within the jurisdiction. The court may dismiss the proceedings of its own motion. Now, what they're saying there is if the subject matter is outside of the jurisdiction of the court, that court can dismiss the proceedings. And I have to look into more about that because that seems a little strange.
To me, that means that common law jurisdiction is established by a harmed party. So if there's no harmed party there, the court has the option to dismiss it.
To dismiss it,
They're
okay.
saying, we don't have jurisdiction. There's no harmed party here. No harmed party, no crime.
Except for those of us who are on the receiving end of the
Well, yeah, that's why
Of the
Joe
fraud.
says put the people of the state of New York on the stand.
yeah.
You know, that's just a guess, but
And
look into it.
yeah,
more.
that's a guess for me too. Well, I have to look again. Some of these thoughts, the way the legal language goes, sometimes is very. Sometimes I think it's intentionally confusing so that it keeps normal people inhibited from actually reading it over and over again until they get it. The judgment of conviction pronounced by a court without jurisdiction is void, and one imprisoned thereunder may obtain release by habeas corpus. And that's Johnson versus Lewis, 144 U.S. 653. So any conviction can be challenged based on jurisdiction and procedural conditions that existed at the time, before trial, during trial, after trial. And that's something important for folks suffering out there to know, that jurisdiction can always be challenged before, during, and after. That's an important point. When jurisdiction has been found to have been flawed or non-existent, then the ruling is voided and that person vindicated. Void judgment is one which has no legal force or effect whatever. It is an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time and at any place, and it need not be attacked directly, but may be attacked collaterally whenever and wherever it is interposed. So in the case of my partner, where the due process and equal protection guaranteed by our Constitution, and our Constitution is a contract that the lower court officers, the DA, all the players are bound to, because they are sworn to uphold the Constitution. You see? So if they impinge upon your rights, your inalienable rights that are guaranteed, in our case, due process was not followed right from the beginning, and fraud right from the beginning, then at any time, all the participants, especially since they've been informed, now that a condition of misprision of felony exists, they all know that there's fraud going on, and they're still getting behind it, so they're culpable and they're liable. Can be attacked at any time. We can start suing them now. We can start suing them later, and hold them accountable for their negligence to address applicable law, turning a blind eye and a blind ear to the law. A void judgment, insofar as it purports to be a pronouncement of court, is absolute nullity. Thompson versus Thompson, 238, SW 2nd, 218, and that would be the Texas, and that would be Waco, 1951. Not every action by any judge, I'm going to say that again, not every action by any judge is an exercise of his judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void, of no legal force or effect. That's Yates versus the Village of Hoffman Estates, Illinois, 209, F Supplement 757. It's also in Illinois. That's come up. That's a ruling. All right, so now we're getting into fraud. Let's talk about fraud for a minute here. Why is there fraud? All right, now, in the lower courts, in your municipal courts, the judge is a clerk, masquerading as a judge. And the reason is because the lower municipal court is a commercial court, it is not a superior court. And the reason that it is a commercial court is because it is incorporated. The judge is not neutral or unbiased. This is conditions of fraud, right? The judge is working for the prosecutor, and they are conspiring in their so-called court. So the judge really is supposed to be neutral and unbiased, and is as a protection and check against a malicious prosecutor. And when that fails to happen, then you have a biased judge, and then you have, again, a failure of jurisdiction. Fraud, under fraud some more here. They're not competent to do justice in subject matters that exceeds the jurisdiction of that court. And lastly, a corporation does not have standing to do anything in any court. And that's where it's real fun and handy to get a Dun & Bradstreet report on a local municipal court and to check up on whether that court is acting outside its purview or its authority. And that's called ultra vires. It is a fundamental right of a party to have a neutral and detached judge to preside over judicial proceedings. Ward versus Village of Monroeville, and there's a lot of rulings on that thought. Lots of numbers there that you can look up. My opinion is and long has been that the mayor and aldermen of a city corporation, all right, now what's a city corporation? would that be a municipal court? That would be the town, right? The town board would be a corporation. The town
Yeah, even the county,
and the county would be a corporation.
county supervisor,
Supervisors, mayors, aldermans.
they're officers in the corporation.
Right? And then you have, or the president and directors of a bank, or the president and directors of a railroad company,
Railroad, huh?
and of similar corporations are true parties that sue and are sued as trustees and representatives of the constantly changing stockholders. All right? Let's read that one more time. My opinion is, and long has been, that the mayor and aldermen of a city corporation, or the president and directors of a bank, or the president and directors of a railroad company, and of other similar corporations are the true parties that sue and are sued as trustees and representatives of the constantly changing stockholders. A corporation, therefore, being not a natural person, flesh and blood like you and me, but a mere creature of mind, invisible and intangible, fall within the terms or the power of the above-mentioned article, and can therefore neither plead nor be impleaded in the courts of the United States. Now, how that applies is that in our situation, the accuser is being masked by the prosecutor's office, who has now taken on the cudgel of pressing the charges and prosecuting as the people of the state of New York versus my partner and I. Well, the people of the state of New York are not a harmed party. They are a corporation. And a corporation cannot operate through the aegis of the court system in this sense. So the officers of the court are exceeding their boundaries.
I think it's because the corporations have to be represented in court by attorneys, and since the attorneys weren't there, it's hearsay.
Right. Well,
That's why you need an affidavit sworn to under oath that you were harmed. Otherwise, the police can't run out and follow up every
Right.
complaint. Some people just might be malicious, fabricate something, just do it for sport. So you have to do it, an affidavit signed to under oath.
Correct. And additionally, adding to that, fraud, big capital letters, fraud here, for any court case to have a plaintiff like state of Texas, state of New York, state of California, United States, etc., or any corporation, is a fraud. You have to have a person,
Natural person.
a natural person, in order for the complaint, the charges, to have validity. So we're having a fiction. This is a court fiction. When you're finding yourself being hounded legally by the people of the state of New York or any other entity that's a corporation and not a real person, then you are being defrauded. It is fraud. Now we get into some other ideas here. There's a bill of attainder, means legislative acts, no matter what their form, that apply either to named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without judicial trial. That is prohibited. All right. Bill of attainder. And it's archaic, meaning a special legislative act that imposes death sentence on a person without trial. The second meaning, bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution, Article 1, Section 9. let's see, Article 1, Section 10, Clause 1, and then the first one's Article 1, Section 9, Clause 3. Also termed an act of attainder. See Attainder Bill of Pains and Penalties. And you can find that in Black's Law. Bills of pains and penalties, a legislative act that, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Bills of pains and penalties are included within the U.S. Constitution's ban on bills of attainder. So, a lower court acting outside of its jurisdiction, assigning a penalty or a incarceration or other kind of, like a fine or something like that of greater than a certain amount is prohibited under the Bill of Pains and Penalties and under Bill of Attainder. So there's another problem there. There's another that's again falls under fraud. Once a fraud, always a fraud. These are maxims of law, okay? Things invalid from the beginning cannot be made valid by subsequent act. So our accuser, having done so much wrong right from the beginning, cannot be justified with any other surrounding actions by, say, the prosecutor or the court or the accuser themselves. A thing void in the beginning does not become valid by lapse of time. That's pretty self-evident. In other words, it starts out rotten, it stays rotten, it never gets better. It just stays rotten. Time cannot render valid an act void in its origin. It's sort of the same thing. Once a fraud, always a fraud. Out of fraud, no action arises, and any act by a government official to conceal the fraud becomes an act of fraud. Okay? So once the court officers and police and everybody knows it's fraud and they don't do anything about it, they are now accomplices to that fraud. It is a fraud to conceal a fraud. That's another maxim. That's a Bouvier's maxim of law. Fraud and deceit should never excuse no man. Wait a minute, hang on. Fraud and deceit should excuse no man. That's another maxim of law. Any fraud amounts to injustice. And another one, this is a good one. Fraud and justice never dwell together. What otherwise is good and just, if sought by force or fraud, becomes bad and unjust. And then lastly, brutum fulmen. I love that. Brutum fulmen. An empty noise, an empty threat, a judgment void on its face, which is in legal effect no judgment at all, and by which no rights are divested, and from which none can be attained, and neither binds nor bars anyone. That's Dolert versus Pratt Hewitt, Oil Corporation, and there's a bunch of numbers, and that's in Black's Law, 4th edition. So there's some real good stuff for everybody to chew on and think about. And I'm just seeing here if I got some other goodies here.
Can you go another hour? I'll give you my time. I'd be honored.
Oh, I don't know if I can go another hour.
You're at 59 minutes.
Right. I can. Do you have something to put on, or?
Yeah, I can.
All right. Well.
But I mean, we don't. It's not 8 o'clock until 10 minutes.
Yeah.
So want to go 10 more minutes?
I'll go.
Do an hour and
I want to share some definitions, Black's Law definitions here that are pretty entertaining. And one is color of law, and this is really something important because this is existent in our case as well. The appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with authority of state is action taken under color of law. So, the whole all the proceedings, starting with the police taking the complaint seriously, even though it was a fraudulent complaint, with, shall we say, questionable evidence, alleged evidence, has now really abused their authority because they're acting with the clothing that they're wearing, the uniform and the badge, but they're acting in an improper manner. They haven't vetted the information. They haven't done their research. They're just
those sheep
acting.
Are frauds. They're really wolves.
Yeah. Yep. As used in Civil Rights Act means the same thing as state action, and means pretense of law, and includes actions of officers who undertake or to perform their official duties. So they're taking actions under the guise of official duties when they don't have that authority. That's kind of acts under color of law of a state include not only acts by state officials within the bounds or limits of their lawful authority, but also acts done without and beyond the bounds of their lawful authority, provided that in order for unlawful acts of an official to be done under color of any law, the unlawful acts must be done with such official is purporting or pretending to act in the performance of his official duties. That is to say, the unlawful acts must consist in an abuse or misuse of power which is possessed by the official only because he is an official. In other words, they scare you into thinking that they have the authority to arrest you or to arraign you or to do a number of things to you when they do not have that authority. That's under color of any law. And the unlawful acts must be of such nature or character and be committed under such circumstances that they would not have occurred but for the fact that the person committing them was an official then and there, exercising his official powers outside of the bounds of lawful authority. So that's under color of law, folks. Kangaroo court, I love that term, but it's a real term, and it is defined as term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or other tribunal. And I mentioned earlier chain of custody, and this is in evidentiary rules, and this is another failure in our case. There is no chain of custody. In evidence, the one who offers real evidence, such as the narcotics of in a trial drug case, or in our case stolen property, must account for the custody of the evidence from the moment in which it reaches his custody until the moment in which it is offered in evidence. And such evidence goes to weight, not admissibility of evidence. So, in other words, in this search and seizure failure, there should have been a policeman with an unbiased witness, which would be, generally speaking, another policeman, and a third policeman who takes custody of the alleged evidence that was confiscated or recovered, or however you want to term it. And they all have to sort of sign off on each other as corroborative attendance to the proper execution of the search warrant. And without a chain of custody of evidence, there is no evidence. You have to have real evidence, and iPhone photographs don't constitute real evidence. Especially, maybe in a civil, but not in a criminal condition or charges. Now, unlawful entry is affected upon lands, can be affected peacefully and without force. So let me read that again. Unlawful entry. An entry upon lands affected peacefully or peaceably and without force, but which is without color of title and is accomplished by means of fraud or some other willful wrong. And that's what we had going on when these three women came and accosted my partner. They came under a ruse, and once inside the home, the party began. Now, another condition of our situation is invasion of privacy, and that is the unwarranted appropriation and exploitation of one's personality or the publicizing of one's private affairs with which the public has no legitimate concern, or wrongful intrusion into one's private activities in such manner as to cause mental suffering, shame, or humiliation to a person of ordinary sensibilities. All right, you can see eavesdropping and privacy acts. Violation of that right of privacy, which one has to be left alone and unnoticed if he so chooses. Such invasion may constitute actionable tort. So if somebody is clocking you and hiring a private detective and finding out who your clients are and then using that information to besmirch your reputation and assassinate your character, you have invasion of privacy, folks, and that's one of the conditions that we're suffering. Libel and slander are both methods of defamation, the former being expressed by print, writing, pictures, or signs, the latter by oral expressions or transitory gestures. That's also a condition here. And I stumbled into something the other night that I found really interesting. It's called the Clean Hands Doctrine.
Oh, yeah.
And under Clean Hands Doctrine, equity will not grant relief to a party who, as actor, seeks to set judicial machinery in motion and obtain some remedy. If such party in his prior conduct has violated conscience or good faith or other equitable principle. So, if you've acted unequitably, don't expect any equity back, because you're not entitled to it. And that's some of the interesting notes that I have there. So I'm going to close the show out with, again, gratitude to our venue here at Woodstock TV, WATV, and I want to thank the town for supporting us here, and again, condolences to the Wilbur family. And I only got to chit-chat and meet Jeremy a couple of times, and we had really entertaining, lovely conversations, and I'm sorry I didn't get to know him better. And thank you, Paula Gloria, for engineering tonight.
Thank you.
And I hope everybody has a great new year, and keep watching. Good night.
Good night. And may you be a great peacemaker in this town, George.
Well,
Thank you.
we'll do our best, right?
It's an honor to tech for you.
All right.
Okay. This is Paula Gloria, and today, these are Sundays that I usually do sessions on Marshall Rosenberg's nonviolent communication and corporations. The purpose is to figure out if we can pierce the corporate veil. The corporate veil is where principles can, well, the justification is not to hide behind a corporate veil. The justification